I'm looking forward to the banana one, so let's do the banana one first. I might not have a banana hat, but I do have a hat that's kind of bananas. So we'll talk about this ridiculous story with a ridiculous hat, courtesy of Kaylee, my wife, who knitted this for me by hand. So there is a conclusion in the banana duct tape to a wall copyright infringement lawsuit that's been going on since 2021. If you don't know the background, there's going to be some background in here and some pictures too, but there's a whole story about it on my channel from, I guess, 2 years ago. It's Joe Morford versus Maurizio Cattelan, and this is the order on cross motions for summary judgment, which means both parties filed motions for summary judgment. Summary judgment means we skip the trial and we can resolve things here because there are no issues to be resolved in front of the jury, like witness credibility or competing evidence or something like that. No genuine issues of facts that are material, genuine issues of material fact. And this is Judge Robert N. Scola Jr., United States District Judge for the Southern District of Florida. And Judge Scola writes, "Life imitates art far more than art imitates life," says Oscar Wilde in The Decay of Lying in 1891. Few people, least of all Maurizio Cattelan, probably expected that his now famous absurdist display of a banana duct taped to a wall at the Art Basel Miami in 2019 would end in litigation. In 2020, however, fellow visual and conceptual artist Joe Morford bringing this action for copyright infringement. Morford alleges that Cattelan's banana on the wall from Art Basel, named Comedian, unfairly copies his own banana on a wall work named Banana and Orange. We'll see a picture in a moment. Previously, the court denied Cattelan's motion to dismiss Morford's complaint. In doing so, the court found that it could not resolve the alleged similarities or dissimilarities between the two works as a purely legal matter based only on the pictures and descriptions provided in Morford's complaint. Now, after the close of discovery, both Morford and Cattelan move for summary judgment, asserting that Morford's sole claim for copyright infringement can be resolved on the record. The undisputed material facts are these. So the judge couldn't resolve things on the motion to dismiss because that's more of a legal motion, and this is more of a factual motion after discovery. Of course, after discovery means we've had 2 years of litigation, and discovery means the parties are probably into the upper 5 digits or lower 6 digits of attorney's fees, or at least effort if the attorneys aren't charging them that much. There's a lot of work to be done to get to this point and file a motion for summary judgment. In fact, it's probably more work to do a motion for summary judgment than it is to just go to a simple jury trial in such a thing. But why take the risk and uncertainty of a jury trial when you could get this instead? Especially if the opposing party is going to do it anyway. Maurizio Cattelan, a self-described visual and conceptual artist and Italian citizen, designed Comedian for the Art Basel Miami Art Fair in December of 2019. Comedian, a banana duct taped to a wall, was meant to be simple, banal, and to reflect absurdity. Joe Morford, a California citizen who is also a conceptual artist, designed his own banana duct taped to a wall work in 2001. The two works are provided below, with Morford's Banana and Orange on the left and Cattelan's Comedian on the right. And I'll sort of describe these in case you're listening and not watching. On the left, we have 2 green frames or panels. They have masking tape, like wide masking tape as a border or frame around them. And you have 1 frame on top and 1 frame on the bottom. On the top frame is the orange. On the bottom frame is the banana. Starting with the bottom frame, the banana is just a banana duct taped to the green frame, the green backing. And it's more or less a horizontal banana and more or less a vertical piece of duct tape, slightly skewed by maybe 15 degrees to the clockwise direction. Above that is an equal size rectangular green frame with masking tape around it. This time, the same masking tape also is a smaller frame on the inside around the orange, and then the duct tape is placed over the orange and the masking tape pretty much exactly horizontal. The orange is round, so of course its angle is not really matter. But the duct tape goes across the middle of the orange. So you see the equal amount on top and bottom, pretty much, with a little bit of error in there. On the right, the image of comedian is a banana in more or less standard banana orientation. It's a pretty banana. It's not strangely shaped banana or anything. The duct tape is going 45 degrees to the right across the banana, and the frame is just a plain white frame in more or less a landscape format. The court now reviews the undisputed facts as they stand with regards to the composition of each work. So think of my description there and what you would have seen on the screen, and then try and think of how would you describe this if you were a judge, and see how that compares to how the judge is about to describe it. First, the basic similarities. Both works are three-dimensional wall sculptures depicting bananas that are duct taped to a vertical surface. In each sculpture, a single piece of plain gray duct tape crosses a yellow banana at an angle and affixes the banana to the vertical surface. In both sculptures, the banana is oriented with the stalk on top, left-hand side of the work from the viewer's perspective. Second, the more specific characteristics of each work. Banana and orange depicts both a banana and an orange, with an orange taped above the banana. Both the banana and the orange are centered on solid green rectangular panels. Each of these panels is bounded by plain masking tape. Both pieces of fruit are plastic sculptures. The orange is duct taped with the tape running nearly horizontal, while the banana is at a slight angle, less than 45 degrees from horizontal, with the stalk of the banana rising and pointing slightly towards the left, and the duct tape crossing the banana in a nearly perpendicular manner. Comedian, meanwhile, depicts only a banana duct taped directly to a wall. The banana in Comedian is a real banana. Any regular banana from a store may be used in the work. The work does not specify a specific color for its background. Any wall will do. There is no border around the banana. Because the banana is taped directly to the wall, Comedian sets out a very specific height at which it is to be placed above the floor. The exact specifications were filed under seal. The court need not recount them precisely here. Instead, the court observes that Comedian has such height specifications and will only address them in reference. Apparently, the height of the banana from the floor is critical to the recreation of this work, the Comedian work. Okay. The banana is placed with the stalk to the left, and it is at a strong angle greater than 45 from horizontal, with the stalk rising and pointing back toward the right. Morford originally developed Banana and Orange in California in 2001, and the work has been available on the internet through several websites for a number of years. Banana and Orange was first made available on YouTube on July 18, 2008, and has been viewable in a brief portion of a video there since. The work has also been shared on Facebook through a single post and on Blogspot via a blog post since July 23, 2015 and July 2, 2016. Morford registered a copyright in 2020. He originally submitted his application January 25th, 2020, after an initial denial and resubmission, and it was approved on November 19th, 2020. Cattelan, defendant, on the other hand, submits his own declaration and the declaration of one of his employees in Italy describing the process by which he created Comedian. Cattelan relates that he conceived of the idea for Comedian in response to a request in September of 2019 to present a work at the Art Basel Art Fair in Miami, scheduled for December of 2019. Cattelan drew his inspiration from an idea he had previously used in a work for New York Magazine in 2018, where he had depicted a banana hanging from a billboard with red duct tape. Based on this inspiration, Cattelan made some changes to the New York Magazine banana piece and asked his employees in Italy to test out bananas taped to the wall of his studio at different heights and angles. Cattelan chose the final specifications for Comedian following that experimentation. One of Cattelan's employees, Jacopo Zotti, corroborates Cattelan's account of Comedian's development process. Finally, Cattelan expressly states that he has never heard of Joe Morford prior to this lawsuit and was similarly unaware of Banana and Orange. Previously, in its order denying Cattelan's motion to dismiss, the court observed that it thankfully did not have to determine what art is to resolve the thorny issues before it. Now, presented with a fulsome factual record and cross motions for summary judgment, what art is looms closer in mind. Fortunately, the court still need not attempt to answer that age-old and frankly unanswerable question, but the court must resolve here whether it can find that one artist's banana duct taped to a wall is in fact an infringement upon another's, or whether such an issue must be decided by a jury. Art may not be easily definable, but life does imitate it, even in its absurdities. To succeed in a claim for copyright infringement, a plaintiff must prove two elements. 1. Ownership of a valid copyright, and 2. Copying of constituent elements of a work that are original. Copying requires both factual copying and legal copying. A plaintiff must show both that the defendant actually used the copyrighted work, and that, 2, the copied elements are protected expressions such that the appropriation is legally actionable. So, when you're doing substantial similarity, you need to show access to the original underlying work. There's that famous Dennis the Menace story where two different artists created two different Dennis the Menaces at the same time, and they are not copyright infringement of one another because they didn't know. They didn't create them based on the other one. They created them independently. Not copyright infringement, even if they're strikingly similar at that point. You can rebut the presumption that they had access. So if you didn't have access and you created it independently, case over already. First, a plaintiff must show factual copying by either direct evidence or indirect evidence demonstrating that the defendant had access to the copyrighted work and that there are probative similarities between the allegedly infringing work and the copyrighted work. Access requires proof of a reasonable opportunity to view the work in question. Second, legal copying looks to whether the similarities between the two works extend to the work's original protectable elements. In most cases, a substantial similarity between the allegedly offending program and the protectable original elements of the copyrighted work establishes actionable copying. But not all aspects of a work are protectable. It is an axiom, or a key element of copyright law, that the protection granted to a copyrightable work extends only to the particular expression of an idea. Only to the particular expression of an idea, and never to the idea itself. Therefore, courts must assess both the quantitative and the qualitative significance of the protectable elements that the infringing work purportedly copies from the copyrighted work as a whole. Morford argues that he is entitled to summary judgment because there is no dispute of material fact that Cattelan had access to banana and orange, that comedian has substantial similarities to banana and orange's protectable elements. Cattelan, of course, argues the opposite, that Morford has failed to put forth sufficient evidence of access, and comedian is sufficiently dissimilar to banana and orange's protectable elements. Cattelan argues that he has put forth evidence that he independently created comedian, which Morford has failed to rebut, and that Morford's claims are precluded by the doctrine of merger. So that's another one that's important. Merger doctrine means there's only so many ways to express an idea, so the sort of idea and expression stays on the idea side, and you can't copyright ideas. So can you copyright the way you express 2 plus 2? No. You have to write the number 2, you have to write a plus sign, you have to write the number 2, you have to write equals, you have to write 4, okay? There's no real other way to write that. That's the mechanics of a language. It's not a protectable element. Now, in that case, it's probably not merger doctrine, but that's the idea, though, is you can't express 2 plus 2 equals 4 in any other way. Maybe you can find a cool, artsy way to make some, like, one-eyed pyramids and some circles with little tick marks on them or something, and you like make 2 of them and whatever. That's fine. Like, you can protect the heck out of the extra that you added on it above the protectable elements, but you cannot copyright the idea of 2 plus 2 equals 4 or the simple expression of 2 plus 2 equals 4 because the idea and the simple expression of it merge. Now, when you encounter something like something as simple as a banana and an orange taped to a wall, or just a banana taped to a wall, how many other ways can you express whatever the idea is behind a banana taped to a wall? You're trying to express some kind of artistic idea, the absurdity of the thing. Is there another way to express this idea? Could you use another piece of fruit? Well, maybe the banana has significance. Does someone own the concept of taping a banana to a wall from a copyright perspective? Well, the judge is going to answer that one. Morford fails to put forth sufficient evidence demonstrating that Cattelan had a reasonable opportunity to view banana and orange. So Morford had to present evidence of access, and he was unable to present evidence of access. Morford argues that because he posted it on the internet, that Cattelan had a reasonable opportunity to view banana and orange. But mere availability and possibility of access is not sufficient to prove access. Mere speculation and conjecture are insufficient. A plaintiff cannot prove access by demonstrating that a work has been disseminated in places where a defendant may have seen it. The plaintiff puts forward no evidence here supporting a reasonable opportunity for Cattelan to have viewed banana and orange. His evidence amounts to no more than proof that his work was available on one Facebook post, one YouTube video, and one blog post. Nowhere is Morford able to demonstrate that banana and orange enjoyed any particular or meaningful level of popularity. In fact, the evidence cited supports the opposite finding, that it remained a relatively obscure work with very limited publication or popularity. He's not able to show a nexus between Cattelan and himself, like a connection between the two of them or something. The court cannot find, based on these facts, that Cattelan had access to banana and orange. Okay, so the case is over there. But here's what I was talking about. The elements, the protected elements, are not protected. They're unprotected. The court's determination of legal copying is based on a century-old understanding that unprotected material should be disregarded when comparing two works, from the Newman case. To understand whether material is protected and therefore determine whether two works are substantially similar in a legally protectable manner, the 11th Circuit has prescribed the use of the abstraction filtration comparison test. We've gone over this before, but we're going to go over it again. In order to ascertain substantial similarity under this approach, a court first breaks down the allegedly infringed program into its constituent structural parts, the abstraction. Next, the court sifts out all non-protectable material, filtration, and finally, the last step is to compare the remaining kernels of creative expression. So, very similar test to other courts, just they call it this abstraction filtration comparison test. So, the abstraction part requires the court to reverse engineer the work. To do so, the court must dissect the allegedly copied work's structure and isolate each level of abstraction. In undertaking this test, the court is guided by the principle so articulated by the judge with the best name ever, Judge Learned Hand, when addressing abstraction. Upon any work, and especially upon a play, a great number of patterns of increasing generality will fit equally well, as more and more of the incident is left out. The last may perhaps be no more than the general statement of what the play is about, and at times consistent of only its title. But there is a point in this series of abstractions where they are no longer protected, since otherwise the playwright could prevent the use of his ideas, to which, apart from their expression, his property never extends. In separating banana and orange into its abstract parts, then, the court will seek to separate Morford's expressions from his ideas. The court has previously reviewed banana and orange to apply the abstraction test. The same analysis applies here. The court found these to be the abstracted elements of banana and orange. Morford's banana and orange features two green rectangular panels, each seemingly attached to a vertical wall by masking tape. The panels are stacked on top of each other with a gap between each. Roughly centered on each green panel is a fruit, an orange on the top panel and a banana on the lower panel. The orange is surrounded by masking tape, and a piece of silver duct tape crosses the orange horizontally. The banana is at a slight angle, with the banana stalk on the left side pointing up. The banana appears to be fixed to the panel with a piece of silver duct tape running vertically at a slight angle left to right. The court will again review the filtration test applying these abstracted elements. The filtration step is based on the idea that copyright protection extends only to the expressive elements, not the underlying idea. Generally, the burden of demonstrating that a particular element of a work should be filtered out during this stage falls on the defendant. The court will first approach the filtration analysis by assessing whether Cattelan can meet this burden. But before the court begins its analysis, it must first review the items it's previously decided before the summary judgment motion on the motion to dismiss. First, the court decided that Morford cannot claim a copyright in the idea of affixing a banana to a vertical plane using duct tape. Okay, so that was the motion to dismiss denial. So allowing Morford to go forward, but giving him a sentence of caution. He cannot claim a copyright in the idea of affixing a banana to a vertical plane. So he should have known that he was not going to win the case. Second, Morford cannot claim a copyright in bananas or duct tape, I guess separately. The court did find that Morford may be able to present some more specific aspect of banana and orange that is protectable, but because the argument was not developed at the time, the court did not determine how the merger doctrine might apply. It will do so now. As noted above, copyright normally protects the expression of ideas, not the ideas themselves. By way of example, the expressions in the novel Moby Dick are protected by copyright, but the idea of hunting a formidable whale at the lead of an eccentric captain is not. This idea-expression dichotomy is the normal standard in copyright law, but under the merger doctrine, expression is not protected in those instances where there is only one or very few ways of expressing an idea. That protection of the expression would effectively accord protection to the idea. The 11th Circuit has offered a few examples. For example, the everyday prohibited sign merges with the idea that something is prohibited, making the classic circle with a diagonal line crossed through it unprotectable even as an expression. Similarly, an alphabetical arrangement of a business directory cannot be protected because it is the only way to construct a useful business directory. In other words, when the way to express an idea is so limited in practice that separate expressions of the idea will necessarily be the same, the expression is not protectable. The parties argue vigorously over whether the merger doctrine is at all applicable to the concept of a banana taped to a wall with duct tape. Cattelan, unsurprisingly, advocates that the idea of duct taping a banana to a vertical wall surface and the expression are essentially one and the same. Morford, in turn, argues that the doctrine is wholly inapplicable. He asserts that the method both artists chose, the banana and the duct tape placed at essentially perpendicular angle with a single piece of tape crossing the banana with the two objects forming an X, is a creative choice that can be copied. Guided by the 11th Circuit's decision in BUC International, the court finds that the merger doctrine is applicable, although not as broadly as Cattelan argues. While addressing the merger doctrine in the context of software programs, the 11th Circuit offered an analogy that is spot on to the present situation. Like the prohibited sign, there are only so many ways to express the concept of a banana taped to a wall. Since... Hi. You have made me a banana hat. I guess we're going to switch ridiculous hats now.
I think it might be a bit too big.
It might be a bit too big. It's definitely awesome. Beautiful, everyone. There it is.
There.
All right.
You can see the
Yeah.
view.
All right. No, you're fine. Sorry, she says. Sorry. I just delivered this awesome present. Sorry, she says. Thank you very much, my love. Continuing on with our new hat. Like the prohibited sign, there are only so many ways to express the concept of a banana taped to a wall. Quote, since there are effectively only a few ways of visually presenting the idea that an activity is not permitted, copyright law would not protect the expression in this case, i.e., the circle with the line through it. The method chosen by both Morford and Cattelan, the X shape of the duct tape crossing the banana in a perpendicular manner, essentially merges with the concept of taping a banana to a wall. It is, to put it bluntly, the obvious choice. Placing the tape parallel with the banana would cover it. Placing more than one piece of tape over the banana at any angle would necessarily obscure it. An artist seeking to tape a banana, or really any oblong fruit or other household object, to a wall is therefore left with only a few ways of visually presenting the idea, all of which involve a piece of tape crossing the banana at some non-parallel angle. Where does this leave the court's filtration analysis? Effectively, it removes from consideration the largest and most obvious abstracted element of banana and orange, the banana, that appears to be fixed to the panel with a piece of silver duct tape running vertically at a slight angle left to right. This expression is not protectable under the merger doctrine. But that is not to say that Morford's work is wholly unprotectable under the doctrine, and this is where the court diverges from Cattelan's position. There are still protectable elements of Morford's work. 1. The green rectangular panel on which the fruit is placed. 2. The use of masking tape to border the panels. 3. The orange on the top panel and banana on the bottom panel, both of which are centered. And 4. The banana's placement at a slight angle with the banana stalk on the left side pointing up. Having reduced the protectable elements of Morford's work to these 4 elements, the court is now going to compare them. The comparison step is perhaps the most direct, although it still has its nuances. Once the court has broken down the original work into its relevant parts and filtered out the unprotectable elements, the court must compare the allegedly infringing work with the protectable parts that remain. The court's substantial similarity inquiry focuses on whether the defendant copied any aspect of the protected expression, as well as an assessment of the copied portion's relative importance with respect to the plaintiff's overall work. Did you copy the heart of the work, or did you just copy something on the fringes of importance? Considering the filtered protectable aspects of banana and orange and comparing the associated aspects of comedian, the court arrives at the following list of comparable elements of each work. On the background element, banana and orange is a solid green rectangular panel. Comedian specifies no background, any wall may be used, white space was used. On banana and orange's border, which was plain masking tape, comedian has no border. On the placement of banana and orange, banana roughly centered in the bottom panel below orange with the stalk placed on the left-hand side. In comedian, the banana was placed at a specified height above the floor with the stalk placed to the left-hand side. And banana and orange's angle was a slight angle, less than 45 degrees, with the stalk of the banana rising and pointing slightly towards the left, where comedian has a strong angle, greater than 45 degrees, with the stalk of the banana rising and pointing towards the right. Reviewing these elements as a whole, it is clear that banana and orange and comedian share only one common feature that the court has not already set aside as unprotectable. Both bananas are situated with the banana stalk on the left-hand side of the sculpture. This solitary common feature is, on its own, insignificant and insufficient to support a finding of legal copying. And the placement of the banana's stalk would be another element subject to the merger doctrine anyway. There are only 2 ways the stalk may be placed, to the left or to the right. The remaining features are simply too disparate to support a finding of substantial similarity. Banana and orange's background is green and not a part of the wall. Comedian's background is always the wall itself. It just so happens that in the infamous Art Basel display, the wall was white. Banana and orange has a border of masking tape. Comedian has no border. It is simply a banana on a wall. The banana in banana and orange is roughly centered on the green backing and placed below a similarly centered orange. The banana in comedian is placed relative to the floor, rather than relative to a piece of backing or other object taped to the wall. Finally, banana and orange's banana is placed at a different angle than comedian's. Morford makes much of the fact that the banana's angles are relatively similar, but this point actually works against him. There are only so many angles at which a banana can be placed on the wall, 360, unless one breaks the measurements down beyond degrees. Finding that Morford's and Cattelan's selections of different angles were close enough to reach substantial similarity would necessarily place a significant legal limit on the number of ways a banana can be taped to the wall without copying another artist's work. In other words, the court would need to do that which it has already said it cannot do, find that Morford could copyright the idea of duct taping a banana to a wall. Finally, these differences are not intentional dissimilarities, as Morford argues, that would allow the court to find legal copying despite the differences. Intentional dissimilarity, a doctrine that, to the best of the court's determination, has not been applied in the 11th Circuit, allows a court to support a finding of substantial similarity if certain dissimilarities in the works are particularly suspicious. This is for all the people who ask me, how much of a work do I have to change in order for it to not be copyright infringement? How much can I copy and get away with it? Is what that question really is. And here's the court's answer: the intentionally dissimilar test. This concept does not help Morford's claim. To find that genuine differences between Morford's and Cattelan's works can be disregarded as intentionally dissimilar would be to find that Morford could essentially copyright the idea of a banana taped to a wall. This the court will not do. Instead, these differences demonstrate that comedian and banana and orange are different expressions of the underlying idea. While the court was previously unwilling to find that comedian was not substantially similar to banana and orange, it was working under the 12b6 motion to dismiss standard without the benefit of discovery. Now, the court is confident. The lack of similarity between the two works is now clear and inescapable. Accordingly, the court finds that comedian and banana and orange are not substantially similar, and therefore Cattelan cannot have legally copied Morford's work. The court goes on to dispose of more access arguments. They summarize that Cattelan was the only party that put forth evidence addressing access and independent creation. So the court grants defendant's motion, denies plaintiff's motion, closes the matter, pending motions denied as moot. Done and ordered June 9th. Robert Scola, United States District Judge. As it should be. So the whole concept of taping a banana to a wall and the expression of taping a banana to a wall are the same thing, or so close, and the expression's so limited that you just can't. You can't copyright it. It's too simple. Make something more complex. Make a banana taped to a wall plus a bunch of stuff. You saw that the judge considered protecting the whole work. If someone made a banana and orange taped to green panels in a similar way to Joe Morford, then that would be a much closer case and maybe even go in Joe's favor, especially if you could show that someone intentionally copied those elements from Mr. Morford's work. But that's not what happened here. These things were created independently, and it just sounds like Mr. Morford was maybe upset that the thing he thought of wasn't popular, but the thing they thought of was. It happens. Sometimes an idea doesn't work for one person, but it works great for another, and yeah, that feels unfair. And I understand that feeling, and I'm sympathetic to that feeling, but it's still not the way U.S. copyright law works. Anyway, let me know what you think in the comments below. It was a great case about the merger doctrine and about the importance of protectable elements being the thing that we copyright, the elements that rise to the level of copyrightability, and we don't protect things that just look the same. That's not the standard for copyright. You have to do a little bit more of a legal inquiry there. Anyway, let me know what you think in the comments below. Are they going to appeal it? Of course they have the right to appeal.